On the Sunday afternoon in question, the victim was fatally shot while sitting in his car. His 11-year-old son, a passenger in the car, was the only eyewitness. The son testified that two men, one of whom had a gun, approached the car and demanded the victim's jewelry. The unarmed man took the son out of the car. He saw his father then get shot. The men pulled the victim out of the car and then drove it away. Crime scene investigators located a portion of skin near the bullet hole in the victim's shirt. DNA analysis determined that the skin matched Dixon's DNA profile. Dixon was arrested, taken to the police station, and read his Miranda rights. He invoked his right to remain silent and right to counsel. Dixon was later booked into the jail. That night, the detective, while at home, received a page from someone in Miami. He called the number, and the unnamed person at the other end told him he wanted to set up a three-way phone conversation with Dixon at the jail. The detective then called the jail, but could only arrange a conversation between himself and Dixon. On the phone, Dixon initiated the conversation by telling the detective that he wanted to make a deal. The detective told Dixon that he could not make a deal, at which point Dixon said that the detective was going to find my stuff all over that guy. I want a deal. The detective ended the call. Dixon moved to suppress the detective's testimony regarding that statement over the telephone. The court denied the motion and admitted the testimony at trial. And there was lewd and lascivious conduct involved in this case, which was proscribed by Section 800.04 of the Florida Statutes, 1997. We affirm all points without discussion, except that urging the lower court erred in denying appellant's request to instruct the jury on lewd and lascivious conduct as a lesser offense to that of sexual battery. This court has previously stated that one cannot be convicted of committing a lewd and lascivious act on a child less than 12 for conduct that also constitutes the offense of sexual battery. They argue that he is entitled to the instruction as a permissible lesser included offense to sexual battery because the jury could have rejected the testimony of the state witnesses and decided that no sexual battery occurred, and it could have determined as well from the evidence that the appellant was guilty only of a lewd and lascivious act. We cannot agree. Appellant was accused of committing capital sexual battery in violation of Section 794 because he, as a person 18 years of age or older, placed his mouth on the vagina of the victim, a person less than 12 years of age. The allegations clearly comply with the definition of sexual battery, which, as set out in Section 794, describes such conduct as oral, anal, or vaginal penetration by or union with the sexual organ of another or the anal or vaginal penetration of another by any other object. In defining the offense of a lewd and lascivious act, Section 800 of the Florida Statutes has, by specifically excluding sexual battery as a means of perpetrating such an act, removed sexual battery as an element invoked in the commission of a lewd and lascivious act. The statute provides a person who handles, fondles, or assaults any child under the age of 16 years in a lewd, lascivious, and indecent manner. 2. Commits actual or simulated sexual intercourse, deviated sexual intercourse, sexual bestiality, masturbation, sadomasochistic abuse, actual lewd exhibition of the genitals, or any act or conduct which simulates that sexual battery is being or will be committed upon any child under the age of 16 years, or forces or entices the child to commit any such act. 3. Commits an act defined as sexual battery under Section 794 upon any child under the age of 16 years, or knowingly commits any lewd or lascivious act in the presence of any child under the age of 16 years. Thus, the above provisions make clear that the offenses of sexual battery and lewd and lascivious act are mutually exclusive, a conclusion the Florida Supreme Court reached in State versus Hightower, 509 Southern Reports, 2nd, 1078, 1079 Florida statutes.
That was kind of tough.
A lot of words you don't get very often. Sexual words, vagina. But got it right. How was that? Fast?
Yeah, let's go.
Want to try some?